And now I'd like to introduce attorney at Holland & Hart, Calder Huntington.
Hello, everyone. So just to start, I want to kind of cover what exactly it is we are going to be discussing today. First, I want to be clear. When it comes to the regulations involved in selling, producing, all that stuff regarding marijuana, that is not what we are talking about today. What we are talking about today are the regulations about medical marijuana in the workplace. What employees' protections exist, what employers can do, what employers have to do. In doing that, we're going to cover a little bit about the difference between federal and state laws, or at least Nevada laws, related to marijuana, our particular medical marijuana accommodation provision here in Nevada, the practical issues related to that and how employers need to deal with it and how they can react to the changing situations in our workforce. And then we're going to talk about some of the cases that have come out of other states, and we're going to be talking about cases from other states because we unfortunately do not have any cases here yet. And so a little bit of what we're doing is prognosticating and guessing as to how our courts will react to our state laws. And then we'll do just a little bit of tip giving as far as drug testing policies. And one other thing I want to bring up, I am happy to take questions. I encourage you to send in any questions through the web system that you may have, and we'll be taking a look at those throughout and seeing what we can do to help. So the first thing people need to understand is that marijuana is still illegal under the Controlled Substances Act, the federal law that governs drugs ranging from Schedule 1 through Schedule, I believe, 4, and that covers all types of drugs, everything that's prescription-based and above. Marijuana has been designated as a Schedule 1 drug under the Controlled Substances Act. What this means is that the federal government considers it to be one of the most dangerous of narcotics and that it has no currently accepted medical use. And so the question then becomes, well, how do we have medical marijuana when the feds are telling us that there is no currently accepted medical use? And that is the key conflict between state and federal laws. The feds consider marijuana to be in the same category of drugs as heroin, LSD, ecstasy, and those types of drugs rather than in Schedule 2 or Schedule 3, which includes things such as oxycodone, oxycontin, morphine, those type of painkiller drugs, narcotics that are frequently used in hospitals, prescribed by doctors. While certain drugs such as oxycontin are considered by the federal government to have a high potential for abuse, they are also considered to have a currently accepted medical use. And that's where the distinction between marijuana and other drugs is between the federal government and the state government, or our state government. And the same distinction is playing out in many states across the country. At the moment, there are 23 states that have accepted or permitted the medical use of marijuana in some form, plus the District of Columbia. Not all of those state laws are the same, and that's going to play a big part of our later discussion today. How exactly the different states have legalized marijuana is very different. Some states have just made it no longer criminal conduct to have medical marijuana if you have a particular identification card, if you have a prescription from your doctor. Though when I say prescription, it's technically not a prescription, just because what a prescription is governed by federal law. In Nevada, what it is a recommendation from a doctor for medical marijuana and not a prescription in the same sense as you would get for antibiotics or other federally recognized drugs. In addition to the 23 states that have legalized medical marijuana in some form or fashion, 4 of those states have also legalized recreational marijuana. Those states are Washington, Colorado, Oregon, and Alaska. There are a number of states that are looking at doing that, including Nevada. There is substantial discussion in the legislature. I believe it has been proposed. I'm not exactly sure where the current legislation is or at what what stage of the process it's at, but there is substantial discussion about legalizing marijuana for recreational use here in Nevada. And while I can't give you a timeline for that, obviously we should probably be aware that there is at least a decent possibility of that becoming the law in the next 5 to 10 years, and it's very possible that it could be less time than that. Whether it happens at all, I don't know, but it is quite possible. That's the same slide, basically. Those are the different states. You can see that the majority of the medical marijuana states are on the West Coast and the Northeast, with a spattering in the upper Northwest, but really it's the West Coast and the East, the Northeast. So, getting to Nevada's medical marijuana law, which I think is what most of you are here to discuss more so than anything else. A little background: in November of 2000, medical marijuana was approved by the voters, but it was not a particularly important issue to most business owners at that time because of the limitations placed on it. At that time, it was no longer a crime to, or at least it was an affirmative defense to use medical marijuana, but there was no legal way to obtain it except for growing it yourself. There was no dispensaries allowed. There were no sellers allowed. If you were buying it from somebody else, you were still dealing with a criminal drug dealer, essentially. Oh, we've just got a note, and I can't confirm, but I believe medical marijuana will be on the ballot in 2016 and voted on by the people. It could be legal as early as 2017, which does not surprise me at all. It wasn't until June of 2013 that Nevada passed the dispensary law, and it wasn't until this last summer where the first dispensaries began to open. And so now it's becoming a much larger issue to business owners because it is becoming more available to the populace through legal means, or at least semi-legal means, which is what we will get to somewhat. So before we get into the details, I kind of glossed over this, but medical marijuana is still, any form of medical marijuana is still illegal at the federal level. Here in Nevada, that is no longer true. There is a process under NRS 452A to get a medical marijuana card. And this is what becomes important to us. Under the Nevada law, NRS 452A.800, employers are not required to allow the medical use of marijuana in the workplace or modify the job or working conditions of a person who engages in the medical use of marijuana that are based upon the reasonable business purpose of the employer. This seems easy enough. You can have a complete ban on marijuana in the workplace regardless of it, if there's a medical purpose to it, regardless if the person has a medical marijuana card, regardless of whether it is technically lawful under state law for them to possess and use the marijuana. It's the second part that starts to get complicated. You don't have to modify the job or working conditions of a person as long as it's based on reasonable business purposes. The question then becomes, what does that mean, and how does that interact with the rest of the statute? When we move on, the statute demands that employers attempt to make reasonable accommodations for the medical needs of an employee who uses marijuana for medical purposes. These two provisions almost seem contradictory at times. You don't have to modify the job or working conditions of the employee, but you have to make attempts to reasonably accommodate them. What accommodation can you make without changing the working conditions in some fashion? And that's where it really is complicated. And there are further exceptions to the reasonable accommodation requirement if it poses a threat of harm or danger to persons or property, imposes an undue hardship on the employer, or prohibits the employee from fulfilling any and all of his or her job responsibilities. So let's first deal with some of the exceptions. The threat of harm or danger. Those are things that are considered under the ADA, the Federal Americans with Disabilities Act. And so we have some basis on which we can compare to ADA case law to figure out what that means. Whether the Nevada courts will interpret it directly along those lines, we don't know because, again, we simply don't have the cases out there yet. But what we can surmise is that if an employee uses heavy machinery, say they're a construction worker, chances are that the courts will accept that you don't have to make reasonable accommodations for that employee to use medical marijuana. The question then becomes, do you have to let him take a different job? Does you have to give him, quote-unquote, light duty or office work if he has to use that, such as may theoretically possibly be the case under the ADA. Under the Nevada law, you don't have to change the person's working conditions. And so that's where the conflict that I just mentioned comes into play. That question is unanswered. I think that you have a good argument that you do not have to change that person's job, and that because in that job they would pose a threat of harm or danger to persons or property, you can terminate that person. The safe course, however, would be to avoid that situation if possible and see if there is another job that they could do. Are you required to? I don't know, and we're not going to know until there's a court case, but it seems unlikely. What about the portion about whether it imposes an undue hardship on the employer? There we get into things where there are other regulations, contracts, or things that would make it difficult for the employer to accommodate the employee. So if a company has a contract with another company that prohibits the use of marijuana or prohibits the use of this or that, then you have an argument that would impose an undue hardship. Or say you're a federal contractor and you have the, what's that statute called? Drug-Free Workplace Act of 1988, which we will get to in a little bit. There's an argument to be had that if you're subject to those regulations, it might impose an undue hardship. However, as we'll get to, a lot of people misconstrue what that statute actually requires. And then again, that prohibits the employee from fulfilling any and all of his or her job responsibilities. That gets back to the question of, do you have to provide him a different job? It seems not, but it very much could land you in a lawsuit if that's the way you go. Would you win? I think you have a good chance. Most employers would prefer to avoid litigation in the first place. So some of the practical issues that you are likely facing is whether or not you should continue or begin to implement pre-employment drug testing, and what you can do if you have positive test results. The big question that comes up is, can we enforce a zero-tolerance drug policy? And as a practical matter, I think that is no longer an option for Nevada employers. A zero-tolerance drug policy for most employers is off the table. Construction employers, potentially. But then you still have to look at secretaries, office staff, and those individuals. Chances are for those employees, no, but you might be able to do so for certain categories of employees. And then the question is, when do we actually need to accommodate medical marijuana? So let's handle the drug testing policy in the first instance. Do you continue to want to have drug testing policies? I think if you have one, there's no reason for you to cease using one at this time if you have good reasons for it. The only problem is that you have to, if you have a positive test, you need to discover what the reason is and allow the employee to explain, provide a medical marijuana card, show that he is using medical, or he has the lawful right to use medical marijuana in the state, and see if there's a way to accommodate that employee. You cannot, at this point in time, choose to terminate or to not hire an employee simply based on the failure of a drug test. If it turns out that they tested positive for a drug different than marijuana, different story, you can go about as previously. If it's marijuana, you have to go through these steps. And then you only need to consider accommodating the employee if they have a medical card. If they do not have a medical card and they just say that they're using medical marijuana, they have XY condition, the use of medical marijuana is still not allowed unless they've gone through the process of getting the medical card. Now, this might be something some employers don't like, but my understanding is, and I have not gone through this process, but it is relatively easy to get a medical marijuana card. Actually, there's a question pending. Let me take a quick look so I can potentially answer that. All right, so there's a current question, and I'm going to read it so that you have a better understanding of what's going on. There's an organization that provides services to people with intellectual challenges, and some of the staff have to drive them and be able to give emergency care. And the question is, and they are funded by state and Medicaid. Do they have to tolerate staff on any type of drug? So that brings up an interesting question, particularly when you say any type of drug. Under state law, you kind of have to consider medical marijuana as you would any other prescription drug. So that's when the question, any type of drug, becomes interesting. If an employee has a prescription for, say, Oxycontin, a pain drug, do you have to accommodate that? That falls under the ADA, and you would have to accommodate as long as it is reasonable. Would that necessarily fall under employees who are driving and have to be called on to give emergency care on an imminent basis? We'd have to get into the details, and you'd have to talk with, I would suggest you contact legal counsel and that to go much further into the details on that. But there's a good chance that no, at least for those particular positions, you do not. However, then, as far as the employer as a whole, you still have to look at, well, do we have secretarial staff? Do we have copy room staff, mailroom staff, staff that isn't in the position of driving the individuals, that isn't in the position of giving emergency care to the individuals? And those people have an entirely different situation than those who are interacting directly with the company's clients. In that situation, you really have to look at them very differently and treat them very differently. Okay. So the specific issues with general drug testing. This gets complicated. So the source for a lot of the information on this slide is the HHS Medical Review Officer Manual, which was last updated in 2004. So not only is it 12 years old, but because of the way the federal government has looked at marijuana generally over time, there has actually been very, very little research done on it. I've had discussions with a number of medical review officers, the people who look over drug testing results and go over the analysis of that, work with employees regarding those results, seeing what the actual issues are. And most of them acknowledge that we just don't know that much about the effects of marijuana, how long it lasts in different people, what the differences between people are as to those effects, etc. However, the federal government has put out that marijuana of any kind can affect an individual for 4 to 8 hours. Theoretically, might be able to affect them up to 24 hours. And it is known that a positive test can occur weeks and months after somebody last ingested any kind of marijuana. And so that really gets into the difficulty with pre-employment drug testing. Though it has to do with all drug testing. The fact that somebody uses medical marijuana at 6 o'clock after their shift, goes to sleep, comes in for a secretarial position the next day, there's a real question whether that marijuana would affect the way they do their job in any way. Most of the individuals I've spoken to, most of the medical review officers and doctors I've spoken to, their belief, and again, there's just not enough research done at this point to really say one way or the other, or at least that's been fully vetted research anyway, to say exactly what that effect will be at that time period. And so to use a medical marijuana, to use a test, a drug test, to say somebody is impaired is particularly problematic. You just don't know when it was that they had the marijuana in their system. Now I want to talk a little bit about the Drug-Free Workplace Act of 1988, which I mentioned earlier is a possibility to say that an employer would be under an undue hardship to accommodate somebody who uses medical marijuana. The Drug-Free Workplace Act applies to government contractors with contracts of over $100,000, or contractors or grantees. The problem is most people believe this requires the employer to have a actual drug-free workplace. Rather, what it requires is that they must certify they will provide a drug-free workplace, publish a drug-free workplace policy, and to report certain incidents of drug use. It most certainly does not require drug testing. There is no mandate under the drug-free workplace that an employer test its employees for drugs. What an employer has to do, and if you're a federal contractor, I would advise that you talk with your legal counsel to get really detailed into exactly the requirements of the Drug-Free Workplace Act. But what it generally requires is that if an employee is convicted of a criminal drug offense that occurs in the workplace, the employer must take disciplinary action, refer the employee to a rehab or drug abuse program, and report that incident to the government. That is a far cry from immediately terminating the employee, whereas many people are under the mistaken belief that that is required, and it simply isn't. And so while there is an argument that accommodating a person who uses medical marijuana in the workplace would create an undue burden if they are subject to the Drug-Free Workplace Act, it isn't quite clear that it would pass muster before the court, because you can do most of these things while still accommodating an employee that's using medical marijuana. And this, I think, is where the real conflict will come, and potentially will be one of the first cases that gets decided here in Nevada because of the issues involved. The other regulations that I think are much more beneficial to being able to terminate an employee is DOT testing. So the Department of Transportation does require certain drug and alcohol testing for safety-sensitive positions. Definitely not all positions. Again, we go back to the office staff, assistants, and those individuals who are not driving vehicles. As they are not required to undergo the same testing that a truck driver does. However, any truck driver, pilot, school bus driver, they show you a medical marijuana card and try to tell you that they get to use medical marijuana, and you can show them the door pretty safely. Might it result in litigation? There's always that possibility, but you're pretty safe in that circumstance. That is an undue burden to have them not be able to pass DOT testing regulations. So with pre-employment testing, as we discussed, impairment really isn't the issue just because you don't know that just because somebody failed the drug test that they were impaired at the time of the test. It's just that some amount of the, in marijuana's case, the metabolite, a digested portion or result of the digestion of marijuana is in the system. If somebody fails a pre-employment test, depending upon the job, you have to go through the reasonable accommodation process. Reasonable suspicion testing, however, is different. In this context, what you're testing for is when an employee is showing signs of impairment, signs of drug use on the job. And this is where Nevada employers should really focus their training and attention at this point. Really, the key issue is to train your managers, your supervisors, to be aware of the signs of marijuana impairment. If somebody is impaired on the job, you have a good reason to terminate that employee for unlawful drug use. While it may not be unlawful at the state level, it's still unlawful at the federal level. And if they are impaired and unable to do their job, even the Nevada laws allow you to terminate that employee. Does the actual testing prove that the person was on the drug at the time? No. And so that's why you need to have your supervisors be aware of what's going on and document the facts as they observe them, that somebody was unable to stand up straight, that they were wobbly, that whatever it happens to be in the individual case. And then you can go from there. Post-accident testing is another issue, and it gets a little more questionable again. If you can document the same kind of conduct as in the suspicion testing, then you're in a good situation. But say you have two employees who were driving somewhere for a meeting and there's an accident, and so you do post-accident drug testing, and the passenger tests positive for medical marijuana. It is very unclear that you would be able to terminate that employee, because even if they had used medical marijuana in the recent past, it likely did not cause the accident. It was the driver who may have or may have not, depending on what happened. If he was just rear-ended at a stoplight, even there, the medical marijuana isn't necessarily related, and so you get questions there. In such a circumstance, if you have a post-accident drug test positive for medical marijuana and they have a drug card, that's the time where you really need to consult counsel and figure out how to react in the individual circumstance. But here, too, it is unclear to what you can do. And so we're running a little short on time, but I want to talk about just a few of the cases that are out there from different states. So Nevada is not unique, but it's a little different than most states in that it has these express provisions protecting employees who use medical marijuana. Most of the states with medical marijuana laws do not provide similar protections. So the most recent case that I'm aware of, and there's a recent one from New Mexico as well, I'm not exactly sure which each came out, but the recent case out of Colorado is Coates v. Dish Network, where a quadriplegic worker for Dish Network used medical marijuana at home to treat his pain and muscle spasms. He performed his work completely satisfactorily at Dish Network, but he was eventually subject to a drug test, a random drug test, and he was terminated for having tested positive. He sued under a statute that basically just said, and Nevada has a similar one, but you cannot terminate for an employee for engaging in lawful activities outside of work. The initial purpose of those statutes was to protect tobacco smokers. You couldn't terminate somebody for smoking tobacco outside of work, even though you could keep them from smoking at work. The Colorado Supreme Court has agreed with the other similar decisions, that the lawful activity statute does not apply because it is an illegal activity under federal law and therefore cannot be considered a lawful activity even though the state does not prohibit it. There are similar decisions out of California, out of, again, I believe New Mexico, and out of Oregon. All states that have very liberal marijuana laws, Colorado and Oregon being two that have actually legalized marijuana for recreational use. So in some ways they are further afield than Nevada as far as who can use marijuana, but less restrictive on an employer on whether you can terminate somebody for using medical marijuana, or any kind of marijuana in the case of Oregon and Colorado. And so these are the questions that employers have. And the way that we at Holland and Hart have been dealing with is to change drug policies to look more at impairment rather than simple testing, and to compare medical marijuana to other, I don't want to say similar drugs, but other medically approved drugs that are medically approved at both the federal and state level. So if somebody tests positive for morphine, you generally have to figure out why that is. If they have a prescription for it, you have to work with them through the ADA. If they test positive for marijuana now, you have to work with them through the Nevada statute, even though the ADA, the federal ADA, would not apply. So our biggest tip for drug testing policies is to look to things more for impairment than simply failing a drug test, and to compare marijuana more to other prescription medications than to other unlawful drugs such as heroin, LSD. And that is about all the time we have today. So I thank you very much for your time and for your interest, and I'd be happy for you to contact me at any time if you have further questions.
Again, I just wanted to let everybody know you can ask a question by typing it into the chat box in the bottom left corner of the screen.
And yes, somebody's pointing out you also need to know if the worker has a prescription for the marijuana or the morphine, and those are the issues that generally go with the medical review officer if you have drug testing policies, and they work that out with those individuals behind the scenes.
Well, it doesn't look like we have any more questions, but definitely feel free to reach out to Calder directly if you have a question. I want to thank you again for joining us today. Thank Calder as well as Holland and Hart. And if you're interested in more Chamber University webinar series, just give us a call here at the Chamber, and we're happy to get you scheduled. Thank you so much again, and we hope you have a great weekend. Thank you.